Now that we're an open carry state, let's talk about the limitations that we expect the state legislature to impose on the open carry of firearms. Let's start by looking at New York Pistol versus Bruen so we can get a better understanding of the Supreme Court's logic in making this determination. In New York Pistol versus Bruen, the Supreme Court was asked to strike down New York's laws regulating the carry and possession of pistols. The court gave the government just one task: find us a comparable law back in history that showed you were allowed to regulate firearms under the Second Amendment the way you're trying to do this now. The government presented the court with a wide-ranging span of laws dating from the 1200s all the way through 1920. The Supreme Court wasn't having that. The relevant time to evaluate was during the founding of the country, and they put a boundary on it between the late 1790s and the mid to late 1800s. The purpose is to understand the interpretation of the Second Amendment around the time it was ratified. The government provided the court with laws in three different categories. At common law, they identified a fray, which is kind of like fighting. They also pulled statutes from the western frontier. We had a westward expansion. The courts didn't necessarily keep up, and so by the time many of these states became states, those laws about open carry and concealed carry of firearms were deemed unconstitutional. And finally, the government brought up surety laws. Essentially, if someone said you were a threat to the public or somehow mentally deficient, you would have to put up some type of bond, some type of money, or some type of property to establish that you were worthwhile of carrying a firearm. But that was an individual restriction that was imposed once a threat assessment was made. The court wasn't convinced by any of the government's laws they presented. They declared New York's statute as unconstitutional. We had a similar result here in Florida with the McDaniels Court. The First District Court of Appeals was presented with a 100-page PDF document from the Attorney General's office listing out all of these laws through history that restricted and regulated firearms. The first DCA didn't buy that either. So if the government doesn't have any laws, where are we at? Despite not being provided any laws on point, the Supreme Court explicitly stated that the government could restrict firearms possession and open carry inside of sensitive areas. They identified sensitive areas as government buildings and schools as an example. After reading the Florida Attorney General's guidance on the open carry of firearms, I think it's pretty clear to say that we'll be looking at 790.06 subsection 12A as the baseline for our restrictions for open carry. If we open up the statutes and take a look at that list, you'll see that almost everything on there is a government building, a school, an airport, or someplace else defined by the federal government. I think it's solid. I recently did a poll on the channel asking about gun magnets. 55% of you believe that gun magnets are not legal. My question is, given our recent change in the legality of open carry, does that change your position? Interestingly, 70% of you said that even if gun magnets are legal, I do not believe they are tactically sound. I tend to agree with that. I also pulled the arrest numbers in Orange County. So far in 2025, only 10 people have been charged with open carry of firearms. Not that impressive. If you're going to carry a firearm in Florida, there's essentially three different ways you can do it. Carry concealed on your person, carry open on your person, or carry in your vehicle. Each one of those ways has some legal requirements that go with it. In this video here, I discuss the permitless carry of a concealed firearm. Check out that video. Hit it hard.